Hello, my name is Audrey and I'm here with my sister Claire today to preview Moore v. Harper, a major case that the Supreme Court will hear on December 7th.
This case deals with congressional redistricting, but also asks a much broader question. How much say, if any, do state courts have on federal election rules established by state legislatures? Let's dive in.
Moore v. Harper centers on the Elections Clause in the U.S. Constitution, which states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Simply put, state legislatures get to decide the election rules in their state.
Using data from the 2020 census, North Carolina's General Assembly, in other words its legislature, redrew its congressional map. Though it claimed to do so on nonpartisan grounds, others disagreed. They challenged the map as partisan gerrymandering that violated provisions in the North Carolina Constitution.
The North Carolina Supreme Court struck down the map. In line with state statutes, the General Assembly drew another map, which a state court also rejected. The court then adopted a new map developed by the team that evaluated the old plan. This map would only apply to the 2022 elections, in line with a procedure enacted by state law.
Importantly, the court's actions appear to be legal under state law. The question, however, is whether the Elections Clause actually permits courts these powers. And if the answer is no, then the Elections Clause would override state law.
The petitioners argue that the power to regulate congressional elections belongs to the legislatures exclusively. This is known as the independent state legislature doctrine. The petitioners also argue that the Founding Fathers set this in place deliberately, citing a proposal they purportedly rejected, the Pinckney Plan, that would have given the power to regulate elections to states as a whole.
This doesn't mean election rules are completely unmoored. Congress may regulate election rules, but not the courts, the reasoning being that legislatures are more accountable to the people than unelected judges. Further, since it's the federal Constitution that governs this issue, courts could still hear federal challenges.
The respondents argue that state legislatures have central but not unlimited authority to regulate elections. Specifically, states can authorize state courts to review redistricting plans to ensure that they comply with their state constitutions. Like other state laws, election rules should be subject to judicial review. Moreover, respondents question the historicity of the Pinckney Plan. For instance, it did not appear in the historical record till 3 decades after the Constitutional Convention.
Respondents also contend that ruling for the petitioners could upend elections. Regulating elections might be too extensive a task for state legislatures alone. It might also create a disconnect between how states run state and federal elections.
The case could significantly impact how elections are run, and by extension, influence election outcomes. As of November, for example, Republicans control approximately 54% of state legislative seats. In the short term, a ruling for the petitioners would likely benefit the Republican Party.
But what does this mean in the long term? It'll be very interesting to see what comes up in oral arguments, and a decision is expected by June of next year. Meanwhile, we hope you enjoyed our preview of Moore v. Harper. Thanks for watching!